With just weeks into the 2026 NASCAR Cup Series season, one of the most explosive off-track stories in years has just detonated, and it's dragging an entire race team, a rising young driver, and one of the most accomplished crew chiefs in the sport into federal court. A judge has already issued a restraining order, the damages being sought top $8 million. And the driver caught in the middle just publicly trolled the team, suing his employer on social media. This is not a rumor. This is not speculation. This is a federal lawsuit, and it is unfolding right now. Gibbs Racing has filed suit in the United States District Court for the Western District of North Carolina against Chris Gabehart, the man who spent 13 years building some of the most sophisticated racing operations in the Cup Series, and against Spire Motorsports, the team that just hired him. Named among the defendants is Spire's own Carson Hocevar, the 23-year-old in the number 77 Chevrolet who is currently sitting inside the top 15 in Cup Series points and driving some of the best racing of his young career. Everything that team has been building in 2026 just got complicated in ways nobody anticipated when the season began. Here's what we know right now. JGR alleges that Gabehart did not simply leave for a new opportunity. They allege he executed what their attorneys are calling a brazen scheme to steal proprietary information before walking out the door. According to court filings, JGR claims Gabehart took at least 20 cell phone photos of JGR laptop screens containing confidential data. Race car setups, telemetry, race analytics, and payroll and sponsorship revenue information. Court documents allege that folders on his devices were titled Spire and Past Setups. Google searches for Spire Motorsports were reportedly found on his devices. JGR also alleges he continued accessing their systems while actively negotiating with Spire, and that at least one JGR employee was solicited to follow him out the door. JGR attorney Sarah Hutchins put it plainly in court: he had the keys to the kingdom. The compensatory damages being sought exceed $8 million. JGR is also seeking double damages and attorney fees, which means the total exposure could be substantially higher. U.S. District Judge Susan C. Rodriguez has already moved, issuing a temporary restraining order that limits Gabehart's duties at Spire, specifically barring him from performing work substantially similar to his former role as JGR's competition director. The full hearing is scheduled for March 16, 2026. This case is active. The clock is running. But that's only half the story. To understand why this lawsuit lands the way it does, you need to understand who Chris Gabehart actually is inside the sport, and what it meant when he left Gibbs Racing. Gabehart joined JGR in 2012 as an engineer. Over the following years, he worked his way up to crew chief for Denny Hamlin, one of the most demanding and accomplished drivers in the modern era. In 6 years calling the shots from the pit box on the number 11 Toyota, Gabehart accumulated 22 Cup wins with Hamlin, called 2 Daytona 500 victories, and made 3 Championship 4 appearances. That is an elite-level track record by any measure in this sport. At the end of 2024, JGR elevated Gabehart to competition director, a broader organizational role overseeing the entire race team's competitive operations. It sounds like a promotion. Gabehart apparently saw it differently. According to reporting on the case, he was subsequently pushed to also serve as crew chief for Ty Gibbs, the team owner's grandson, in 2025. Gabehart describes that situation as having become untenable. The tension between his organizational role and the expectation that he would also personally crew chief for a driver in a very politically complicated position at a very powerful team appears to have been a breaking point. In early December 2025, Gabehart met with JGR President Dave Alpern. According to court filings, he told Alpern during that meeting that he had not discussed employment with Spire Motorsports. JGR alleges that was not true, and that as far back as November 13, 2025, Gabehart had already received an offer from Spire, and that on November 7th, he had already begun photographing proprietary materials on JGR laptop screens. Court records also show that on December 2nd, a private investigator documented Gabehart meeting with Spire co-owner Jeff Dickerson in person. JGR did not sit quietly. They hired a private investigator to document Gabehart's movements and meetings. That detail matters, and we will come back to it because one of the defendants in this lawsuit decided to make that detail very, very public. And then came the part nobody saw coming. Carson Hocevar found out about the private investigator, and he went to social media. Hocevar posted on Twitter, referencing the investigators' documented route, and wrote, "They needed a PI for this. They could have just walked next door. That's known as Jeff's table." He attached images of the investigators' reported route, presumably referencing proximity to a known Spire location. It was the kind of post that got attention immediately. It was sharp. It was funny to a lot of people in the garage. And it may turn out to be one of the most legally costly tweets a NASCAR driver has ever sent. Sports attorney Shannon McMenemy flagged the post almost immediately, writing publicly, "Carson getting into hashtag NASCAR commentary. Sweet summer child. He's going to find out about Discovery pretty soon." That is not just social media snark from a legal observer. That is a meaningful warning. In federal litigation, Discovery is not optional. Communications, text messages, emails, social media posts, direct messages, can all be subpoenaed. If Hocevar's tweet reflects any actual knowledge of meetings, locations, or logistics connected to Gabehart's departure from JGR, that information now exists in the public record and is available to opposing counsel. He is a named defendant. His words are now part of this case, whether he intended them to be or not. Gabehart, for his part, is not conceding anything. He denies all of the allegations flatly. He paid for an independent forensic review of his laptop at his own expense, and according to his legal team, the results did not indicate any wrongdoing. His attorney, Kerry Davis, has argued that Gabehart's role at Spire is substantially different from his position at JGR, comparing it to the difference between a football team's offensive coordinator and a general manager or head coach. The argument is that even if Gabehart carried knowledge in his head from 13 years at JGR, his new responsibilities are different enough that the non-compete enforcement JGR is seeking is overreaching. Spire co-owner Dan Taurus went further. His public statement was direct. Spire doesn't want data from Joe Gibbs Racing. It doesn't have data from Joe Gibbs Racing. At no point in time has it had data from Joe Gibbs Racing. Taurus also added a pointed comment about JGR's motivation, saying the lawsuit reflects anger that Gabehart chose to leave for someone other than a blue blood team. That framing matters. Gabehart's own defense appears to be leaning into the same narrative, that JGR is pursuing this because they view his departure as an insult rather than because they have a legitimate claim. The judge will ultimately decide whether that framing holds up. What the judge has already decided, even at this early stage, is that JGR's claims are serious enough to warrant immediate action. A temporary restraining order is not handed out casually in federal court. For a judge to limit an employee's duties at a new employer before the full merits of a case are even heard, there has to be enough on the surface to suggest potential ongoing harm. That is where this case stands right now. But the real fallout did not happen only in the courtroom. Inside the garage, this lawsuit is being watched very carefully, and not just by JGR and Spire. This is the kind of legal action that sends a message across an entire industry. Non-compete clauses exist throughout NASCAR team contracts. Data security, proprietary setups, and analytical tools represent millions of dollars of competitive investment. What JGR is doing here, hiring a private investigator, filing immediately in federal court, seeking damages that exceed $8 million, is a statement about how seriously the sport's most powerful organizations intend to enforce those protections going forward. JGR released a formal statement after the restraining order was issued. "We are pleased with today's ruling by the United States District Court for the Western District of North Carolina for a temporary restraining order enforcing the terms of our contract with Chris Gabehart. We will continue the legal process to protect our information and fight for what is right for our race team, our employees, and our partners." That language, "fight for what is right," is deliberate. This is not a quiet settlement track. JGR wants to litigate this publicly, and they want the rest of the garage to see it. Gabehart's defenders point to a different concern, that heavy enforcement of non-competes restricts the mobility of talented people in a sport that already has enormous power concentrated at the top teams. If a competition director cannot move to another organization without facing an $8 million lawsuit, what does that mean for engineers, crew chiefs, and analysts across the grid? That is a legitimate question the industry is wrestling with right now, regardless of how this specific case resolves. And when you look at the standings now, you will see why this changes everything for Spire Motorsports specifically. Spire is not the team it was 3 years ago. The organization runs 3 cars in 2026. The number 7 Chevrolet with Daniel Suarez, the number 71 Chevrolet with Michael McDowell, and the number 77 Chevrolet with Hocevar. They have a technical data alliance with Hendrick Motorsports, which gives them access to information from the most decorated organization in NASCAR history. Hiring Gabehart was meant to be the next step, adding championship-level institutional knowledge to an operation that is clearly trying to climb into the conversation as a legitimate front-running team. Hocevar's 2026 numbers tell the story of a team that is trending upward fast. He was running at the front late in the Daytona 500 before getting spun and finishing 18th. He came home 4th at Atlanta in a race he nearly won, gaining positions from his starting spot late in the running. At Phoenix, he struggled in the closing laps and was credited with a 20th place finish. For a team that Gabehart's own attorney compared to a non-blue blood organization, the early season performances have shown genuine pace even when the results have been mixed. The restraining order complicates all of it. If Gabehart cannot perform the duties he was hired to perform, overseeing Spire's competitive operations, then the organizational upgrade the team was banking on is currently in legal limbo. Luke Lambert continues as Hocevar's crew chief, and the on-track results have shown enough raw speed that day-to-day operations are clearly functioning. But the broader competitive infrastructure that Gabehart was supposed to help build is now frozen pending the March 16th hearing and whatever follows it. The discovery phase of this lawsuit could get significantly messier. Federal civil discovery means emails, texts, documents, and communications from all parties, including any Spire personnel connected to Gabehart's hiring, can be compelled. Hocevar's tweet, and any related communications around the time of Gabehart's departure, now exists in a legal context. The 21-day window for Gabehart to formally respond to the complaint is ticking, and the March 16th hearing could produce a preliminary injunction, a more formal and longer-lasting restriction than the current temporary restraining order that further limits Gabehart's role through the conclusion of litigation. If JGR wins on the merits, the implications extend beyond this specific case. A federal ruling that enforces an 18-month non-compete against a competition director would establish meaningful precedent for how NASCAR teams protect intellectual property going forward. And $8 million plus in damages, or doubled damages if a judge finds willful misappropriation, would represent a landmark penalty in a sport where such disputes typically get settled quietly. And that sets up what could be the most important off-track storyline of the 2026 season. The March 16th hearing is the next major flashpoint. Whatever Judge Rodriguez decides on the preliminary injunction will either restore Gabehart's ability to contribute to Spire's competitive operations or extend the limitations already in place, potentially for months. Either outcome reshapes this story significantly. If the injunction is denied and Gabehart gets back to full duties, Spire will argue that vindication and push harder into the season. If the injunction holds, JGR will have demonstrated in open court that their case has real merit, and the pressure on Gabehart and Spire to reach a settlement agreement intensifies. Watch also for how discovery unfolds. If Gabehart's independent forensic review is admitted into evidence and supports his defense, the trade secret theft allegations face a direct challenge. If JGR produces device evidence, the alleged photos, the folder names, the Google searches, in a way that the court finds credible, the case against Gabehart gets substantially stronger. And keep watching Carson Hocevar. Not just on the track, where he has shown genuine front-running pace through the early weeks of the season, but in this legal proceeding. He is 23 years old, sitting inside a federal lawsuit, and has already posted publicly about the private investigator his employer's adversary hired to surveil the situation. His social media instincts and his legal exposure are now directly in conflict, and that tension is not going away before the season gets deep into the spring. Spire Motorsports signed up to build a championship-caliber organization. They hired one of the most accomplished competition minds in the garage to help them get there. They did not sign up to be defendants in a federal corporate espionage case before the season reached Race 5. But here they are. And the next hearing is right around the corner. The green flag keeps dropping every Sunday. But for Spire, the most consequential event of their 2026 season might not happen on any racetrack at all.